Start. The tribunal, in the instant case, has issued notices and has called upon the opposite party in the contempt application for appearing before it in order to frame charges and then proceed in the matter full stop. In our opinion, this stage cannot be a stage for entertaining a writ petition on the ground as if the contempt application was not maintainable and the tribunal had no jurisdiction to proceed with the same full stop. To our mind, it appears that the tribunal on a perusal of the order dated 18th November, 2009 as well as the order dated 6th December, 2006 was of the prima facie opinion and disobedience has been committed full stop. The contempt application was filed against 3 named officials full stop. Unfortunately, the said officials, who were summoned in person have not filed the present writ petition full stop. The present writ petition has been filed in the name of the designation of the officials and not in their own personal capacity full stop. The writ petition, therefore, as framed on behalf of the personnel in their official capacity would not be maintainable when the notices have been issued in person to the then officials who were being complained of having disobeyed the orders full stop para. The issue of finality in relation to the dispute of the vacancy and availability of the post of lab assistant was an issue which was decided in paragraph number 5 of the judgment dated 6th December, 2006 as extracted here and above full stop. Even if, it is presumed that the operative part of the said judgment in paragraph number 8 allowed the authority to proceed if the vacancy was available, then too, an order came to be passed by the High Court dismissing the writ petition filed by the petitioners on 27th March, 2008 full stop. The finding recorded in paragraph number 5 of the order dated 6th December, 2006 was therefore, upheld and not set aside full stop. Apart from this, an attempt to get the judgment of the tribunal reviewed also failed and the review application was dismissed on 10th December, 2007 full stop. The respondent number 1 filed a contempt application number 92 of 2007 and the order passed therein and extracted herein above directed the authority to ensure compliance within 3 months full stop. Thereafter also the petitioner general manager passed an order on 25th April, 2008 again rejecting the claim of the respondent number 1 which was set aside in the execution application decided on 18th November, 2009 full stop. The said order in the execution application was never challenged by the petitioners and has attained finality full stop. The petitioner number 1 then proceeded to pass an order on 24th February, 2010 which has given rise to the action for contempt full stop. The contempt application would therefore, be maintainable if a disobedience is being alleged in respect of an order which has attained finality full stop. The defense of the petitioners on this issue can be examined only after the charges are framed and their defense is considered in order to establish as to whether the order dated 24th February, 2010 passed by the general manager is contemptuous or not full stop para. The trial court cannot be preempted by taking recourse to the discretionary jurisdiction or supervisory jurisdiction of this court under Articles 226 and 227 of the Constitution of India, as this would amount to preventing the Central Administrative Tribunal from determining its own authority to proceed in a matter of contempt where disobedience is alleged, full stop. An order amounting to prohibition or a mandamus restraining the tribunal from exercising its authority to examine the nature of the contempt alleged, therefore, would not be permissible under the garb of a writ of certiorari, which has been prayed for to quash the order whereby the officials have been summoned, full stop, over.